Today, I'm going to help you familiarize Article 1156 to Article 1178 of the Philippine Civil Code. If you think my reading is too slow or too fast, you may go to Settings at the right portion of your screen and click Playback Speed and choose the speed you want. Are you ready? Oh, hit that subscribe and like button to keep track of our audio guides. Before I read general provisions under obligations and contracts, I would like to introduce to you our subjects that you may encounter as I read the provisions. If you happen to know these beforehand, wonderful. You may skip to the readings of the provisions. Now, who are these subjects? The subjects that I'm talking about are the creditor/obligee and the debtor/obligor. Creditor or obligee is the person who has the right or power to demand the prestation. Debtor or obligor, on the other hand, is the person to perform the prestation. I don't understand prestation. What is prestation? Prestation is the object of the contract, the performance of something due, and it may be the obligation to give, to do, or not to do. Again, remember, creditor/obligee demands the prestation. Debtor or obligor performs the prestation. Understood? Now let's dive into the provisions under Title I Obligations, Chapter 1, General Provisions. Article 1156. An obligation is a juridical necessity to give, to do, or not to do. Article 1157. Obligations arise from law, contracts, quasi-contracts, acts or omissions punished by law, and quasi-delicts. Article 1158. Obligations derived from law are not presumed. Only those expressly determined in this code or in special laws are demandable, and shall be regulated by the precepts of the law which establishes them, and as to what has not been foreseen, by the provisions of this book. Article 1159. Obligation arising from contracts have the force of law between the contracting parties, and should be complied with in good faith. Article 1160. Obligations derived from quasi-contracts shall be subject to the provisions of Chapter 1, Title 17 of this book. Article 1161. Civil obligations arising from criminal offenses shall be governed by the penal laws, subject to the provisions of Article 2177 and of the pertinent provisions of Chapter 2 Preliminary Title on Human Relations and of Title 18 of this book regulating damages. Article 1162. Obligations derived from quasi-delicts shall be governed by the provisions of Chapter 2, Title 17 of this book and by special laws. Chapter 2. Nature and Effect of Obligations. Article 1163. Every person obliged to give something is also obliged to take care of it with the proper diligence of a good father of a family, unless the law or the stipulation of the parties requires another standard of care. Article 1164. The creditor has the right to the fruits of the thing from the time the obligation to deliver it arises. However, he shall acquire no real right over it until the same has been delivered to him. Article 1165. When what is to be delivered is a determinate thing, the creditor, in addition to the right granted by him by Article 1170, may compel the debtor to make the delivery. If the thing is indeterminate or generic, He may ask that the obligation be complied with at the expense of the debtor. If the obliger delays or has promised to deliver the same thing to two or more persons who do not have the same interest, he shall be responsible for any fortuitous event until he has effected the delivery. Article 1166. The obligation to give a determinate thing includes that of delivering all its accessions and accessories, even though they may not have been mentioned. Article 1167. If a person obliged to do something fails to do it, the same shall be executed at his cost. This same rule shall be observed if he does it in contravention of the tenor of the obligation. Furthermore, it may be decreed that what has been poorly done be undone. Article 1168. When the obligation consists in not doing, and the obliger does what has been forbidden him, it shall also be undone at his expense. Article 1169. Those obliged to deliver or to do something incur in delay from the time the obligee judicially or extrajudicially demands from them the fulfillment of their obligation. However, there are instances when the demand by the creditor shall not be necessary in order that delay may exist. And these are: 1. When the obligation or the law expressly so declare. Or 2. When the nature and the circumstances of the obligation, it appears that the designation of the time when the thing is to be delivered or the service is to be rendered was a controlling motive for the establishment of the contract. Or 3. When demand would be useless, as when the obliger has rendered it beyond his power to perform. In reciprocal obligations, neither party incurs in delay if the other does not comply or is not ready to comply in a proper manner with what is incumbent upon him. From the moment one of the parties fulfill his obligation, delay by the other begins. Article 1170. Those who, in the performance of their obligations, are guilty of fraud, negligence, or delay, and those who in any manner contravene the tenor thereof, are liable for damages. Article 1171. Responsibility arising from fraud is demandable in all obligations. Any waiver of an action for future fraud is void. Article 1172. Responsibility arising from negligence in the performance of every kind of obligation is also demandable, but such liability may be regulated by the courts according to the circumstances. Article 1173. Default or negligence of the obliger consists in the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the persons, of the time, and of the place. When negligence shows bad faith, the provisions of Article 1171 and 2201, paragraph 2, shall apply. If the law or contract does not state the diligence which is to be observed in the performance, that which is expected of a good father of a family shall be required. Article 1174. Except in cases expressly specified by the law, or when it is otherwise declared by stipulation, or when the nature of the obligation requires the assumption of risk, no person shall be responsible for those events which could not be foreseen or which, though foreseen, were inevitable. Article 1175. usurious transactions shall be governed by special laws. Article 1176. The receipt of the principal by the creditor, without reservation with respect to the interest, shall give rise to the presumption that said interest has been paid. The receipt of a later installment of a debt without reservation as to prior installments shall likewise raise the presumption that such installments have been paid. Article 1177. The creditors, after having pursued the property in possession of the debtor to satisfy their claims, may exercise all the rights and bring all the actions of the latter for the same purpose, save those which are inherent in his person. They may also impugn the acts which the debtor may have done to defraud them. Article 1178. Subject to the laws, all rights acquired in virtue of an obligation are transmissible if there has been no stipulation to the contrary. And that's it for today. Comment below for more suggestions for smoother and better listening of Law Daily PH while doing your routines or chores. Have a fruitful day ahead. Gotcha next time!